Namaste, one and all. I am Sridevi Jampani, the founder of Egna Legal. Together with Sri P. Bhaskar, I welcome you all to the today's webinar. We, the team of Egna Legal, have been practicing in both states of AP and Telangana. Egna Legal has been providing services to the clients for all their legal needs. We specialized in civil, criminal, revenue, matrimonial, and service related matters. Now I request Mr. P. Bhaskar to introduce today's panelists.
I take the privilege to introduce Mr. Anil Malhotra, a practicing advocate uh, since 1993 in Punjab and Haryana High Court at Chandigarh and also in Supreme Court. And to be brief, he appeared in several matters before the Haryana High Court, Punjab and Haryana High Court, and also in Supreme Court. And he contributed significantly to the issues of inter-country adoptions, interparental child removal and surrogacy by convening seminars, discussion, debates at India International Center, New Delhi, and other law faculties in association with Law Commission of India and Mr. Soli Sorabji, Senior Advocate and former Attorney General of India. And he has got a lot of international memberships and local appointments. That's all about very brief description about Anil Malhotra ji. And Madam Suri Garu doesn't require even that introduction to AP and Telangana. She is a practicing advocate and known to all practicing advocates and also the litigants in both Andhra Pradesh and Telangana. Madam, now it's over to you, Madam.
Namaste, one and all. It's my pleasure to be here amongst all of you. And my association with Mr. Malhotra has been since 2019, where we actually met at the National Judicial Academy of India at Bhopal. And what I have actually noted in him is his level of energy. It's not sufficient if we have just knowledge or just level of energy. It's a combination of both that makes him what he is. And his unquenchable thirst for knowledge, for improving knowledge. And incidentally, I want to share how all this, this webinar has started. The very idea of this webinar. Mr. Malhotra shares with me any important article or any important, meeting or webinar or anything, information with regard to that. The other day he shared an article with me which I read, and I thought that there are certain things which, we also need to discuss about. And then I broached that before him. He suggested, why don't you organize a webinar? Immediately I remembered Mr. Bhaskar, and I called up Mr. Bhaskar. He was, in fact, very kind enough to take up the lead and organize this webinar. Now, this webinar is on the subject of custody of minor children, and the various laws which deal with this subject. That is actually the entire focus today. What are the laws? Do we have a uniform code in India? We don't, obviously. So what are the laws that we need to follow? What are the laws that actually underlie the principle of, custody of minors or guardianship of minors? Whether it is religion or personal law related, or whether it is a general subject. When it comes to the court, yes, it is a general subject. It doesn't go very deeply into the personal laws. But personal laws do have a say in the matter of custody of children, because basically we don't have a uniform civil code and we do have personal laws. I have done a small study with regard to personal laws, and what the personal law says with regard to the minor children, custody of minor children. I'll just, these are Hindu religion, Muslims, Muslim personal law, Christians, and Parsis. Just a brief, extremely brief comparison. The personal law, from the point of view of personal law, in Hindus, we have the Hindu Minority and Guardianship Act. And of course, the Guardians and Wards Act is common for all. In Hindu Minority and Guardianship Act, the natural father is the guardian is the father. He is treated as the guardian. And of course, the focus there is again on the best interest of the welfare of the minor child. And so far as Hindu law is concerned, personal law, there the consent of the child has a say in the matter of grant of custody. That is there in every law, but looking at it from the point of personal law, the importance given to the child's opinion, it differs from each religion to religion. So far as Muslims are concerned in the Hanafi law, they have, and of course, Guardians and Wards Act goes without saying it, it's applicable to every person of every religion in our country. So far as Hanafi law is concerned, it says that father is treated as the natural guardian and the best interest of the child is the governing factor and the child's opinion is considered. So far as Christian and Parsi personal laws are concerned, practically they are governed by the Guardians and Wards Act only. Then we go to what does Hindu law say with regard to the child custody and guardianship. Hindu law says that the custody of the child below 5 years of age should normally be with the mother and above 5 years it would be with the father. The underlying principle, the purpose of that is, it is considered that children at such a tender age require maternal care and they have to be bestowed that maternal care. So until the age of 5, the child has to be in the custody of the mother. Over and above 5 years, it is the father who is the normal custodian. And here we say, regarding guardianship, the father is the guardian, but in the absence of the father, the mother is also a guardian, the Haryana states. Then we have the question of illegitimate children. Now, in the ancient Hindu law, Hindu religious practices, there was no bar on bigamy. If a person, there was no divorce also. If a person wanted to leave a woman and go with another woman, or if he wants to have the woman under the same roof, he had that liberty. But with the advent of these codified personal laws, a man, a Hindu who is divorced can remarry. But if a Hindu being married and within the marriage before a divorce enters into another wedlock, that marriage is void ab initio, but the children in that marriage who are legally illegitimate children, their custody would be with the mother. Their custody would be with the mother. Then we go to the Hizanat, that is the Muslim law. Under Muslim law, in Muslims also again, there is a small difference. Shia law and Sunni law. Under Shia law, the child would be in the custody, 1 minute. Under the Shia law, mother's right to custody of her minor child extends until the son is 2 years old and the daughter attains the age of 7. Under under Sunni law, under the Sunni practice of this Hanafi law pertaining to Sunnis, the children until the age of 7, in the case of a boy, would be with the mother, and a girl until she attains the age of puberty. Until she attains puberty, shall be in the custody of the mother. If there is a divorce between the parties, the children would be with the mother. If the mother remarries, the father would have the right to take the custody of the children. And here again, the law that governs, I mean, if there is any conflict, I mean, if there is any question mark or any lacuna which would not help the court so far as the personal law is concerned, goes without saying that the matter would fall under the Guardians and Wards Act. In the sense that the interest of the welfare of the minor is the paramount consideration. Then the custody under Christian law and Parsi law is in accordance with, they don't have any special personal law with regard to child custody. And so we have to actually go by the Guardians and Wards Act. In fact, both the mother and father are deemed to be equally entitled to custody in those two communities. And if there is a conflict, the solution would be under the Guardians and Wards Act. Then we go. These are the laws with regard to the custody. These are the rules that govern the custody of the minor children under the personal laws. Now, going to the statutory position, there is, I mean, law for matrimonial disputes as laid down in the statutes, also provides invariably for the custody of the minor children of the parties who are warring on account of their marital disputes. And every marital law, every statute that provides for marital relief also provides for, among other things, custody of a minor child. We start with the Divorce Act, which in fact, the Family Courts Act, Section 7, explanation 1B, it says that declaration with regard to legitimacy can be done by the family court. That is essentially about the jurisdiction. But when we are going through the enactments, which actually provide for for anything related to child custody or anything related to the child, then essentially we have to touch these small points. It provides for Section 7, explanation 1. E says, with regard to legitimacy, the family court would have jurisdiction to decide. That is the correct forum for deciding the legitimacy of a child. Then a suit or proceeding for maintenance that also relates to minor children, and a suit or proceeding in relation to guardianship of the person or custody of the. So, Section 7. Sorry? Right.
ఒకప్పుడు ఉంటుండే మా ఇంట్లో చెట్లు అందరు దింపుకొని పోతుండే.
Some disturbance. Then we have Section 30. We have Section 41 of the Divorce Act, which says, I say, the provisions related to custody of minor children in every marital law is almost identical. Almost identical. It says, power to make orders as to custody of children in suit for separation. That includes divorce, of course. Earlier there was no. Then power to make orders as to custody of children in suits for dissolution or nullity. Separation is one thing, dissolution and nullity are different from separation. That is under Section 43. Going to the Hindu Marriage Act, Section 26. I'm sure all of you invoke this in one case or the other every day. Section 26 of the Hindu Marriage Act. It says that in any proceeding under this act, which means there essentially has to be some provision, some case under the for marital relief under that act. And in such a case, the court has the power to make provision from time to time with regard to the custody and maintenance of the child, and also incorporate the provision about the judgment with regard to the custody, permanent custody or custody in the decree while disposing of the matter. This identical position, this kindly note that normally when we file a petition for interim maintenance, pendentility, that is pendentility maintenance, 24 of the Act provides for interim maintenance of the wife. There were several occasions when 24 alone was mentioned and the interim maintenance for mother and child was sought. They were not entertained. Then we were led to file a provision, we were led to file petitions under section 24 and a separate petition under section 26. But then with a lot of fight and all that, we could bring it to a situation where we file a petition for maintenance of the party and the children in one application only, in one IA only, where we mention both 24 and 26, because it deals with pendentility maintenance of children and it also deals with interim custody of children. I'm sure there are so many cases which we see every day where at the inception of the proceedings, we ask for an injunction restraining the respondent from removing the custody, removing the child from the custodial parent. And this is very common these days. And provision for, permanent custody in the decree is also permissible under the marital law. Then we have Hindu Minority and Guardianship Act. Actually, this is where it started. Mr. Malhotra actually in his article has very clearly stated that the provision as to who should have custody of the minor child under the Hindu Minority and Guardianship Act is provided, but the machinery for working out a remedy is not provided under this act. So it goes to the procedural aspect has to be done, either in random or we have to follow the guardians involved, and that is what Mr. Malhotra said in that article. So that is where it all started, in fact, this discussion about the thing. Then we have who is the natural guardian in Hindu? Section 6 of the Hindu Minority and Guardianship Act. And in fact, in the beginning itself, when I differentiated between the provisions related to the custody and guardianship of minors as per personal law, I clearly stated that a child below 5 years would be in the normally in the custody of the mother, but the guardian is always the father. Then we have the section 38 of the Special Marriage Act. It is similar, rather I should say identical, to the other provisions in the Divorce Act and then Hindu Marriage Act and the other acts. So in the provision in the matrimonial enactments, when relief under the enactments is sought by couples, it does not exclude the question of custody of minor children, and the courts are competent to decide this. And I should mention a case where Mr. Malhotra also knows. There are complications when the child is born in some other country, there is litigation in some other country with regard to the child, or there is a court order with regard to child custody in some other country, and that child is brought to India. What happens after that and all that? That, of course, Mr. Malhotra will explain in detail with all the case law, because he's very, very conversant and he deals with that in almost every meeting or seminar. So he's an expert on that, I should say that. And what happens if there is a conflict between a foreign law and Indian law? That for the first case on that aspect is Dhanvanti Joshi versus Madhav Unde, where it was laid down that when the child is in India, the Indian law would follow. But after that, there have been so many developments, so many, set of circumstances, a combination of circumstances, which warranted the Honorable Supreme Court to give judgments on that aspect. And each judgment, there are even today, there are judgments in favor of the Indian courts deciding the question and the foreign courts deciding the question. Mr. Malhotra will explain, elucidate all those things. And I request all of you to pay full attention because we will not get such an opportunity every day. Mr. Malhotra is an expert on this subject. Mr. Malhotra, please take over.
Thank you, Vani ma'am. Good evening to all. And I'm very indebted to Vani ma'am and the hosts for the show for having me as a speaker and giving me this honor of attending to on this very important subject, which, as we were discussing in the pandemic, has acquired enormous dimension of importance because the sufferers of this time were mostly children who perhaps could not reach out to parents and family members and were involved in disputes which led to their rights being crippled and parents having to go to courts was laid in disarray because of the restriction of the working of the courts. Now, with this brief introduction, I would only concentrate on the smaller aspects because Vani ma'am has done an excellent job in running you through the whole movie on all the laws in a very short span of time beautifully with a very crisp pinpointing of all these statutory laws, the provisions concerning the custody of children, maintenance of children, and giving you a perspective of how many laws are applicable to different personal communities with details of the provisions. Now, as we all know, though we are a sovereign, socialist, secular, democratic republic, as enshrined in the preamble of the Constitution of India, but a uniform civil code, what Article 44 of the Constitution envisions, is still a distant dream. Goa is perhaps the only state which follows the Portuguese code, which is perhaps the only secular law in the country, as insofar family laws is concerned. Because irrespective of religion, Goa being a state where you will find Hindus, Muslims, Christians, everybody lives in harmony. Nobody wants a personal law application. Every marriage is solemnized according to civil law. Ceremonial marriage is optional. Civil marriage is compulsory. In rest of India, it is reverse. The optional marriage, the civil marriage is optional. The ceremonial marriage is compulsory. So with this is the difference we are in. So what is the net result? Every personal law of every community is statutory, approved and enacted by Parliament. The Hindu Marriage Act, the Special Marriage Act, the Parsi Marriage and Divorce Act, the Christian Marriage Act, the Muslim laws are of course uncodified. So all these statutory laws govern the respective communities. Insofar the matters of guardianship and custody are concerned, the Guardian and Wards Act is the secular law which applies uniformly to all communities. But something which a lot of us don't know, and something which I learned over a period of time in dealing with custody matters, I have authored 9 books and I have been associated with the Justice Bindal Committee, which tried to enact a law on interparental, inter-country child custody disputes. Now, in the Constitution of India, under Article 39, in the directive principles of state policy, we say that children should be given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and the childhood and youth are protected against exploitation and against moral and material abandonment. So who is a child? Is a child a person under the age of 18? Legally speaking, yes. But in realistic terms, I would, as Lord Tennyson says, child is the father of man. A child is the most important pivotal support structure which unites parents, extended families, and the societal setup in every community in India. Now, what is the background to which law has come in? India signed the United Nations Convention on the Rights of the Child on 11th of December 1992. So whenever we ratify or accede to a United Nations Convention, we are per force obliged to make an internal law to give teeth to the convention. Now, please, if you have time sometimes, go through the UNCRC. The UNCRC, that is the United Nations Convention on the Rights of the Child, it talks of the child as a person. It talks of a child as a person who has a right to life, right to education, right to parents. Article 8 says a child should have his identity, nationality, name, and family relations recognized by law. Then Article 6 says every child has a right to life. Article 7 says every child has a right to a nationality. Article 3 says there should be best interest of the child. Now, all these rights were very well laid down in the United Nations Convention on the Rights of the Child. We signed it in 1992, but we took a lot of time in incorporating the provisions of the UNCRC in our laws. We did in some places, and now just to give you an idea of where these rights are crystallized, you will find it in the right to compulsory education. You will find it in the POCSO, that is the Protection of Children Against Sexual Offences Act. You will find it in the Commission for Protection of Child Rights Act, which is a law a lot of people don't know. There is a National Commission on Protection of Child Rights, and there is a State Commission on Protection of Child Rights in every state commission. It is a commission with more powers than the High Court, but nobody uses it. You can go to a commission and complain of a violation of a child right, and they have to take redressal. They cannot pass a judgment, but they can refer the matter to the government and ask for action to be taken. A commission can even file a writ petition in a court for redressal. I have, on behalf of the National Commission for Protection of Child Rights, filed a petition in the Punjab and Haryana High Court for creating commissions in Punjab, Haryana, and Chandigarh. After I was a court commissioner, where we reported a serious cases of sexual abuse by a children's home in the state of Haryana. Now, what is most important for our discussion today is, we talk of the welfare of the child, we talk of the best interest of the child, we say for deciding custody, the welfare of the child shall be the paramount consideration. But which is the statute, which is the law which defines the welfare of the child or the best interest of the child? Now, I initially started taking up this proposition in the matters of interparental child custody removals of foreign jurisdictions, which is my specialized area of work. And I found that the definition of the best interest of the child is contained in Section 2, subsection 9 of the Juvenile Justice Care and Protection of Children Act 2015. So this is the JJ Act. Now, the JJ Act was enacted in 1986. It was amended in 2012. Then the most exhaustive amendments came in 2015. And in that came the definition of the best interest of the child in subsection 2(9). Now, please listen carefully what the definition reads, because this is a definition which is secular in nature. Now, the JJ Act in Shabnam Hashmi's case has been clearly held to be a secular law. And Justice Gogoi has very clearly said in Shabnam Hashmi's case that the law of adoptions, being a secular law under the JJ Act, will apply to Muslims. So the law of adoptions applicability to Muslim religion, not permitted by personal law, came in to the Muslim community through Shabnam Hashmi. Because Justice Gogoi said, dehorse your right of adoption under your personal law, you also have a right, and the child also has a right of adoption under the JJ Act. But that be so, the secular definition of the best interest of the child applicable universally to all communities in India is section 2, subsection 9, saying best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. Very wholesome definition. And this definition has been crystallized from the entire provisions of the UNCRC. Now, when I first started raising this argument of applicability of the best interest of the child in child custody disputes in the Delhi High Court, the straight answer was that this is a definition, or this is an act which will apply to children who are in conflict with law. Now, the JJ Act 2015 deals with three categories of children. One, children in need of care and protection, children in conflict with law, and children who have to be rehabilitated through adoption. So my argument was that a child who is in need of care and protection, in the definition given in subsection 214, inter alia talks about the concerned category, I will say, is a child in need of care and protection means, according to what I have said, a child who resides with a person, whether a guardian of the child or not, and such person has injured, exploited, abused, or neglected the child, or has violated any other law for the timing in force meant for the protection of the child. So when a child is removed by one parent to deprive the other parent of his or her rights, the child is a child who needs care and protection because his rights have been violated, the child has been neglected, or the rights of the other parents have been affected. Now I pause here for a minute. Child abduction, child removal by a parent, or kidnapping by a parent, or interparental child removal or abduction, or whatever terminology you may use, in the Indian context is not a wrong, is not an offense. So therefore, whenever there is an interparental child removal, the courts tend to be very lenient, and the courts do not tend to take it as a civil or a criminal offense. However, in 100 countries over the globe who are a part of this United Hague Convention on Civil Aspects of International Child Abduction 1980, which is popularly known as the Abduction Convention, Hague Convention on Civil Aspects of International Child Abduction 1980, interparental child removal is a civil wrong. It says interparental child removal or wrongful retention of a child in violation of the rights of the other parent to the extent of depriving him of the rights which he exercised by force of a law or of an order of a court will amount to interparental child removal. Now, how the system works, once a country signs the convention, country to country, children are returned through a process of a internal authority which has to be established, which will follow an internal mechanism and do it. In India, we do not follow this because we observe the best interest principle, which is given in section 2, subsection 9 of the JJ Act. Now, that being so, because we do not follow wrongful detention or removal of a child by a parent as an offense or a wrong, I think bringing in the definition of the best interest of the child, recognizing the child as a person, recognizing that the child has a right to life, and right to life can go to Article 21, right to life and personal liberty. So therefore, the amplitude is very wide. But then again, the proposition is, how do we bring it within the ambit of the statutory laws? So let us confine our discussion to the majority law, the Hindu Minority and Guardianship Act, and let us take it to the Guardian and Wards Act and the Family Courts Act and see how we take this further. Now, there are a lot of concepts which one can read into after a careful reading of the provisions contained in the, to start with, the Hindu Minority and Guardianship Act. We are all primarily, majority of us are Hindus by religion. So the Hindu Minority and Guardianship Act applies in the respect of children. There may also be provision in the Hindu Marriage Act and the Special Marriage Act, as Vani ma'am told you, in which custody of children can be adjudicated. But you can go to a court under the Family Courts Act through the HMGA and the Guardian and Wards Act only for the custody and guardianship issues. You need not file a petition for divorce to get custody issues resolved. So this is taking the children's litigation out totally from the ambit of the marriage laws. Now, in this backdrop, section 3 of the Hindu Minority and Guardianship Act says, the provisions of this act shall be in addition to and save, not in derogation of the Guardian and Wards Act 1890. So the Guardian and Wards Act 1890 is the pivotal law, even though it is a antique law which is almost 150 years old, but we still continue to follow it. Justice A.P. Shah, in report number 257 given in 2015, had suggested seriously that we should look at this law and bring in changes. He even suggested amendments to the law. He even gave a proposed amended act, but nothing has happened. So we continue to follow what is contained in the 1890 Act. Now, the HMGA does not contain any statutory right which will take you or permit you to use it as a right to file a petition in a court. You have to file it under the GWA. But that be so, who is the guardian? Section 4 subsection B says the guardian is a person having the care of a person, includes a natural guardian, guardian appointed by the will of the father or the mother, and a guardian appointed by the court. Now, section 6, which is the provision which is invariably used by a parent to claim exclusive rights, is termed in very straight words, but it has been interpreted from time to time in different ways. Now, section 6 says that the natural guardian of a Hindu minor shall be the father, and after him shall be the mother. In the case of a boy or an unmarried girl, the father, him, and after. Coming back to section 6, who is the natural guardian? The father, and after him the mother. And Geeta Hariharan's case by the Supreme Court very clearly said in 1999, both father and mother are equal there is no difference. Now, the crunch is, how do we read certain controversial parts of Section 6? Now, Section 6 says natural guardian father and mother, but the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother. Now, this is where the controversy starts. Now, let us first be very, very clear. Natural guardian father and mother, custody of a child less than 5 years of age shall be with the mother. Now, let us understand, it's only the custody which can go to the mother less than 5 years of age, as is what is said in the provision. Please be very clear that the guardianship goes nowhere. We have already seen under the Guardian and Wards Act, the definition of the word guardian is a natural guardian. So a natural guardian cannot be got rid of. A natural guardian cannot be divested of his authority as a guardian by the custody being with the other parent. The only way it can be done is by declaring the natural guardian unfit under Section 19 of the Guardian and Wards Act. I will come to this later when we deal with it. Now, the second issue which comes from Section 6 is the mother can not say, now this is a subject of interpretation, that a child's residence is the residence of the mother. So the mother says, my child is less than 5 years of age, custody is mine, and wherever I live will be the residence of the child. Now, this is not the view which will hold good, because the custody is one, the right of the custody is one part, but insofar the issue of jurisdiction is concerned, that is governed by Section 9 of the Guardian and Wards Act, and under Section 9 of the Guardian and Wards Act, the place of residence of the child is where the minor ordinarily resides. So the residence of the minor is governed by Section 9 of the Guardian and Wards Act and not by Section 6 of the HMGA. Now, I also want to clear one concept which has emerged from judgments of the Supreme Court. And the question which I pose myself and answer is the right of the mother or the father absolute? Can a mother say, child less than 5 years of age, custody is mine? Can a father say, child more than 5 years of age, custody is mine? The answer is no. The answer is no, and the answer is contained in Section 13 of the HMGA itself. Section 13 of the Hindu Minority and Guardianship Act says that in the appointment or declaration of any person of a Hindu minor by a court, the welfare of the minor shall be the paramount consideration. Now, it also says that no person shall be entitled to the guardianship by virtue of the provision of this Act or by any other law if the court is of the opinion that his or her guardianship will not be for the welfare of the minor. So, your right is not unconditional. Your right is regulated by the welfare of the minor. Now, this explanation has been expounded and has found meaning in two judgments of the Supreme Court. The first judgment is a judgment which has emerged from the Andhra Pradesh High Court and has been finalized and upheld in the decision of Lahari Sakhamuri versus Subhan Kodali. Now, this is a reported judgment, Lahari Sakhamuri versus Subhan Kodali. In this judgment of the Supreme Court of the year 2019, the Supreme Court has said in para 43. Now, I'm going to read para 43 to you because what the Supreme Court has done, Supreme Court has read the definition of Section 2(9), best interest of the child, from the JJ Act and has incorporated it in the Supreme Court judgment to say how is Section 6 to be read. Now I read the expression best interest of the child, which is always to be kept paramount, is indeed to be given a wide connotation, and it cannot mean the love and care of the primary caregiver, i.e. the mother, in case of an infant who is only a few years old. So the Supreme Court says under 5, custody with the mother is not an unconditional right. And why? The Supreme Court says the definition best interest of the child as envisaged in Section 2(9) of the JJ Act means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So this is where the Supreme Court departed and held that that best interest cannot remain the love and care of the primary caregiver, i.e. the mother, in the case the infant is a few years old. This was one view propounded in 2019, and in 2022, on 12th of January 2022, in a matter Vasudha Sethi versus Kiran Bhaskar, the Supreme Court upholding the High Court decision in the habeas corpus. I was an amicus in the High Court in the habeas corpus. The child was ordered to be returned to the US with the father, and the Supreme Court upheld the decision of the High Court in doing so. But what is important for our discussion here is what the Supreme Court said about Section 6. Now, Supreme Court says, on a conjoint reading of subsection 1 of Section 13, read with Clause A of the 1956 Act. I have just read 13 and 6 to you. The court says, if it is found that the welfare of a minor whose age is more than 5 years requires that his custody should be with the mother, the court is bound to do so. So they say even after 5, the court finds mother better, please do so. In the same way, it says, the court says, if interest of the minor, which is the paramount consideration, requires that a custody of minor should not be with the mother, the court will be justified in disturbing the custody of the mother, even if the age of the minor is less than 5 years of age. So the Supreme Court has very clearly said, right of a parent 5 years or less or 5 years more is not a vested right of the father or the mother. You have to weigh it in the scale of the best interest and welfare of the child. Now, the second thing which the Supreme Court here says is, if you remove custody from one parent, you must do so. But when the court disturbs the custody of one parent, unless there are compelling reasons, the court will normally provide visitation to the other parent because the child needs both parents. Visitation rights are passed for the welfare of the minor for protection of their right to have company of both parents. Now, it also says, very important, such orders are not passed for protecting the rights of the parents. They say we cannot accept the submission that while applying the welfare principle, rights of the father or the mother need to be protected. The consideration of the well-being and welfare of the child must get precedence over the personal rights of the parents. Now, these are golden words which the Supreme Court is coming out with. Why are we carving out a new jurisprudence in family laws? Because we do not have amended laws which have kept up with the pace of the time. So the Supreme Court, in its wisdom, from time to time is expounding on the rights of the child. A custody petition is not a divorce petition. This is the fallacy which we get into as lawyers and with judges. We start treating a custody petition by arguing which parent is better. It's not about which parent is better. It's about the child. How best is the interest of the child served? With which parent? With both parents? Obviously. We need to look at joint or shared parenting ultimately. The concept of singular custody is outmoded. It's outdated. It's damaging to the interest of the child. No child can grow up with a single parent unless, of course, there are compelling reasons which the court has to come to a conclusion that the parent is unfit because of certain reasons. So this being the situation, this is what is very important. I have dwelt with this proposition so that you get clarity on the proposition, which I have found after a number of years of working in these working on these issues. Now, Section 8 of the HMGA talks of the powers of the natural guardian, and this I have told you cannot be displaced away with. Now, let us come to the law which we have to follow, that is the Guardian and Wards Act 1890. Now, the provision under Section 4, subsection 2 again defines who's a guardian, and it talks of a guardian having the care of a person and both of his property. So that is as far as then Section 7 talks of the power of the court to make an order for guardianship. So it says wherever the court is satisfied that for the welfare of a minor, it can appoint a guardian, it can declare a person to be a guardian. Obviously, Section 4.2 has to be read with this. And who can apply for being appointed as a guardian? Any person who is desirous of claiming to be a guardian, any relative of the friend, and a collector in case there is no one available. Now, the crunch comes in Section 9 of the Guardian and Wards Act. Now, as I already told you, Section 6 of the HMGA, the residence of the mother does not determine where a guardianship petition will apply, will lie. Section 9 says, court having jurisdiction to entertain application. It says if the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. I emphasize the word where the minor ordinarily resides, not where the mother or the father ordinarily resides. So this, in a number of cases, has been held. The Punjab and Haryana High Court has a different view. It says residence of the child is residence of the mother, but there are 6 other high courts in a totally different direction. The 6 high courts say, in a unanimous opinion, that residence of the mother is not the residence of the child. Section 9 of the Guardian and Wards Act determines jurisdiction, not Section 6 HMGA. And as I read out to you, HMGA is only a supplemental enactment. It cannot be in derogation or violation of the Guardian and Wards Act. So that being so, this is how Section 6 has to be read, Section 9 has to be read. Now, before I go further to this, let me give the judgments on the point on how and what a family court can do and what it ought not to do. Now, in this perspective, let us first go to the celebrated judgment of Justice Tirath Singh Thakur in the case of Ruchi Maju. Now, in the case of Ruchi Maju, the court was dealing with the issue of the jurisdiction which had emerged from the Delhi High Court. Now, the Supreme Court, in this decision of Ruchi Maju, which is of 2011, Ruchi Maju versus Jeev Maju, the Supreme Court says in para 60, in cases arising out of proceeding under the Guardian Wards Act, the jurisdiction of the court is determined by whether the minor ordinarily resides within the area on which the court exercises such jurisdiction. There is significant difference between the jurisdictional facts relevant to the exercise of powers by a writ court on one hand and a court of Guardian and Wards Act on the other. Having said that, we must make it clear that no matter a court is exercising powers under the Guardian and Wards Act, it can choose to hold a summary inquiry into the matter and pass appropriate orders, provided it is otherwise competent to entertain a petition for the custody of the minor under Section 9(1) of the Act. So the Guardian and Wards Act jurisdiction is available only if the court has jurisdiction. Now, this aspect I may share with you has also found approval by a recent judgment in Tejaswini God. This is 2019 judgment, Tejaswini God, 2019, where Justice Bhanumati has very well said in very clear words. It says that in cases arising out of proceeding under the Guardian and Wards Act, the jurisdiction of the court is determined by whether the minor resides within the area on which the court exercises her jurisdiction. So the golden words are there. Section 6 HMGA doesn't do it. Section 9 GWA does it. Having said that, let us also understand that if under Section 9 of the GWA, the guardian judge or the family court finds that the child does not live in his or her jurisdiction, then what should he do? Ruchi Maju gives the answer in para 62. It does not hold much persuasion for us to hold that the issue whether the court should exercise or hold a summary or detailed inquiry will arise only if the court finds that it has jurisdiction to entertain the matter. If the answer to the question touching the jurisdiction is in the negative, the logical result has to be an order of dismissal of the proceedings or return of the application for presentation before the court competent to entertain the same. A court that has no jurisdiction to entertain a petition for custody cannot pass any order or issue any direction for the return of the child to the country from where he or she has been removed. No matter such removal has been found to be lawful or in unlawful or in violation of an order issued by the court of that country. The party aggrieved by such removal may seek other remedy legally open, but no redress is available before a court which finds that it has no jurisdiction to entertain proceedings. So if you have a petition in a court where a child is living on the day the petition is filed and the child is not ordinarily residing, an application under Order 7, Rule 11 CPC, assailing jurisdiction, can be made. It is the discretion of the court to entertain it. If it requires evidence, it would be a question which can be determined on facts. You can bring it up in Order 14, Rule 2, Sub-Rule 2, CPC, by claiming that it should be a preliminary issue. That, of course, is again a procedural aspect. But the family court is, under the Family Courts Act, can divest the procedure aspect under Section 12 and 14 because the family court can come to the determination of the case in a much expeditious way. So a writ court under 226 or 32 has vast jurisdiction because it is parens pater jurisdiction. A parens pater jurisdiction is conferred on the court by virtue of the fact that the court has overall control on the child, whether the child is lawfully to be dealt with or not by it, but still the court can take cognizance. So if a court finds that the child is within its jurisdiction in 32 or 226, then the court can pass any order. It can order that the child be kept in India. It can order that the child be returned to the country from where the child was moved. That is the beauty of the Constitution, but this is an extraordinary jurisdiction. It is a jurisdiction vested under the Constitution of India. The jurisdiction exercised by the family court or the guardian judge is arising from a statutory enactment, the Guardian and Wards Act, the HMGA, the GWA. The family court has no powers under the Constitution. So a family court is not a constitutional court. And I will just expound the decision in Aman Lohiya's case. Now, this was a matter which I had argued in the Supreme Court. And where we had dealt with this issue of what is the parameter which the Supreme Court ought to follow. And in that decision, I'll just point it out to you. The Supreme Court had said that the constitution that there is a procedural aspect which necessarily requires to be followed, and there can be no jumping of procedure in that jurisdiction as far as that is concerned. I will refer to this judgment in a little while, but I want to first clear one thing here about the ordinary residence aspect under Section 9. Now, in a decision of the Delhi High Court, which was affirmed by the Supreme Court in JK versus NS, this is a decision of July 1, 2019. This was a matter of two children removed from the US who I had taken up on behalf of the father in the Delhi High Court. I moved the habeas corpus court. The mother moved the Guardian and Wards Act court before the Family Court, under the Family Courts Act. I took an objection that the matter should be dealt with by the High Court only. I moved an application under 711. The application was allowed. The court said it had no jurisdiction. The judgment was affirmed by the High Court, but the Supreme Court said a full trial is needed. It was ordered to be done within 6 months. After 6 months, the Family Court came to the decision that it is in the best interest of the children to be returned to USA with the father. But the concept of the ordinary residence of the child has been dealt with in para 81 of this judgment. Now, the High Court says, having traversed these judgments, now these were the judgments of different High Courts, the conclusion that emerges is that both sections operate independently. So we are talking of Section 9 of the Guardian and Wards Act, and we are talking of Section 6 of the HMG. Section 9 only deals with territorial jurisdiction, and to decide the jurisdiction, what is to be considered is the ordinary residence child. Language of Section 9 is crystal clear and unambiguous, and we are persuaded to adopt the view of the various High Courts above. Once the question of jurisdiction is settled, it is certainly open for a mother to place reliance on Section 6, that is, where a child is less than 5 years of age. However, the converse cannot be accepted. The claim of the mother under Section 6 cannot be used to decide the jurisdiction of the court under Section 9. We are not persuaded to take a different view as has been held by various courts. We reject the contention of the appellant that the provisions of Section 6 will control jurisdiction of the court, since the children are below 5 years of age and are in the custody of the mother at New Delhi, and Delhi courts will have jurisdiction. So this was negative, and the Supreme Court was very clear that Section 6 will not control the jurisdiction in this regards. Now, there is another judgment which I want to refer, and this is a very famous judgment in Ashish Ranjan versus Anupma Tandon 2011, Ashish Ranjan 2010. Now, here the Supreme Court says that though the provisions of the special statutes govern rights of parents or guardians and may be taken into consideration, there is nothing that can stand in the way of the court exercising its parents' jurisdiction. Statutory provisions dealing with custody of the child under any personal law cannot and must not supersede the paramount consideration as to what is conducive for the welfare of the minor. In fact, no statute on the subject can ignore, eschew, or obliterate the vital factor of the welfare of the minor. This was followed in the case of Perry Consagra by the Supreme Court. And very clearly, the Supreme Court said that this is what is going to be the deciding factor. So now, having dealt with this aspect, we come to the order of sequence in the Guardian and Wards Act further. Under Section 17 of the Guardian and Wards Act, the provision says that the welfare of the minor shall be the paramount consideration in deciding. The same principle is followed as in Section 13. So Section 17 of the Guardian and Wards Act says welfare of the minor shall be the paramount consideration. Now, there is some very important provision in Section 17(3). If the minor is old enough to form an intelligent preference, the court may consider that preference. So there is no mandate, there is no compulsion on the court that they have to hear the child. It is the pure discretion of the court that it may consider if the child is old enough to form an intelligent preference. Now, there are several cases where the child being in the custody of one parent may get polarized or may get into what is now commonly known as parental alienation syndrome. If a child remains with a parent for a very long period of time and there is no contact with the other parent, the child gets into preferring the custody of the custodial parent and disliking the non-custodial parent. The child may also be a victim of brainwashing, poisoning, or being fed with negative aspects of the other child. So the child starts behaving in such a way that the child gets alienated or polarized. So in Vivek Singh versus Romani Singh, the Supreme Court has very clearly said that if a child is polarized or if the child is not in a normal way, the court will refuse to consider on how to decide the matter. And until and unless the child is on a level playing field, both parents have equal freedom, the court will not take a final decision. This judgment has actually opened up a lot of fresh thinking in taking cognizance, and for a court to be blindly led by the testimony of a child in the custody of one parent to believe what the child says is gospel's truth has been negative, and this has been done away with because this is considered to be a harmful interpretation for the welfare of the child, because the child is not speaking what he ought to be speaking. Now, with this, we jump to the most important enactment which we now have to follow, and which is the Family Courts Act, which is now the governing factor for us to decide how cases are to go. So first of all, the Family Courts Act 1984 was formed for promoting conciliation and to secure the speedy settlement of disputes in marriage and family and for matters connected therewith. Now, the way I look at it, the Family Courts Act was not meant to forcibly ask people to live together. We have, as you all know it, a divorce structure based on the fault principle. We have 13 grounds, now 12. Leprosy is gone. But we also have a divorce by mutual consent. If you cannot get along, then you can mutually go. You have been separated for 1 year. You go, there is a waiting of 6 months, and you confirm the divorce on second motion. We do not follow the irretrievable breakdown principle, which is commonly available in foreign jurisdictions. And if there is a foreign divorce decree on irretrievable breakdown, we do not recognize it. So the way out is that you also get a divorce on irretrievable breakdown, and you bring in your foreign divorce decree as evidence that you have separated. You settle all issues, you produce that document, it be read as evidence, and as part of the settlement, it is incorporated in the Indian settlement, and then the Indian court passes a fresh order giving you a divorce by mutual consent. It is now common that video conferencing allows parties to appear, and the courts are granting divorce decrees. In our jurisdiction, we are even permitting online registration of marriages. So online divorces are also being granted under mutual consent. Time and technology have hastened the tools of settlement. And I think a positive view in settling disputes is becoming very important, particularly when children, property issues of non-resident Indians are also to be settled in India. So it becomes very important for these matters to be settled. Now, as Vani ma'am put it to you, Section 7 is the wholesome provision on jurisdiction. It says the family court has jurisdiction to decide to the exclusion of district courts. So if there is a high court exercising original jurisdiction, as is common in Delhi, Bombay, and Calcutta, even the high court has no jurisdiction in family court matters, only the district court. And the district court will mean the family court. For what all? First of all, for a decree of nullity, for a validity of a marriage, for property relating to parties, for suit or order or injunction relating to a marital relationship, Now, a suit or an order relating to injunction will also mean anti-suit injunctions. You cannot say that a suit for anti-injunction is not available because it is only injunction. I raised this matter in the Delhi High Court, and the High Court said anti-suit is covered in suit for injunctions. So suit or proceeding relating to legitimacy, suit or proceeding for maintenance, suit or proceeding relating to guardianship and custody. Now, there is one interesting provision I want you to address too, is suit or proceeding for a declaration as to legitimacy of a minor, of a person. Now, I came across a very interesting matter which I argued in appeal on being instructed by a Delhi council. A person had filed a petition seeking declaration that he was the father of the child because he had fathered the child with a lady who was married and who had asked him to enter into a relationship, but the real purpose of it was to father the child. So he sought legitimacy. He sought a declaration that he was the natural father. Surprisingly, the family court dismissed it, saying the suit doesn't lie. I came to the Delhi High Court. There also the matter was not agreed to and I had to withdraw. But it raises a very interesting question. But there is law on it. If the question of legitimacy arises in an ancillary issue, then it can be raised. But if the primary purpose is the suit for paternity or custodial rights on by virtue of being declared a guardian on an extramarital or an out of marital relationship, then it would not lie. But then a question will come, how will we deal with cases of surrogacy? We have now made the Surrogacy Regulation Act. We have made the Artificial Reproductive Technology Act 2021. So if there is a child fathered through surrogacy, can the surrogate mother say, I am the natural mother? These are gray areas. Law, the acts are silent on legal proceedings and paternity and establishment of rights. But these are questions which we will have to look into. What is the right of a transgender? Can a transgender file a suit for being declared a parent? Now, these questions have come in adoption petitions. Now, recently there was a matter before, I think the Kerala High Court probably, where an unmarried couple, that is a transgender and a normal and a person and another person, wanted to adopt a child, but the adoption was not permitted because they were asked to produce a marriage certificate. Now, under law of adoptions, that is the Hindu Adoption and Maintenance Act of 1956, any person can adopt a child irrespective of marital status. So a Hindu can adopt. If he has a wife living, he has to seek his consent. If there is no wife, of course, he can adopt. The only exception being that a man cannot adopt a female child. Likewise is the provision under the JJ Act, where adoptions are permissible irrespective of marital status. So the High Court said, if they want to adopt, there is no requirement of a marriage certificate. But then it also answers the question that you need not have a marriage for adoption of a child. So there are rights of persons of different categories which are emerging. How would the law deal with it? Would the family courts have jurisdiction? These are gray areas which perhaps will come when issues are raised before it. Now, Section 8 says that all courts will have no jurisdiction in matters agitated in Section 7 in respect of issues dealt with by the children. So this is the power of the family court insofar jurisdiction is concerned. Now, Section 10 of the Family Courts Act says that the court shall follow CPC, but Section 10 subsection 3 says nothing in this section shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of subject matter of the suit or to arrive at the truth of facts alleged by one party or denied by the other. So what is the provision saying? It says family court can depart from CPC for procedure. And in doing so, section 14 also says that a family court may receive in evidence any report, statement, document, or any information which in the opinion is necessary to assist it to deal effectively with a dispute, whether the same would be admissible or relevant under the Indian Evidence Act or not. So, family court has got a clear power of departure from CPC, from Indian Evidence Act. So the court can pick up a document and say it will be read in evidence. No necessity of it being admissible or inadmissible under the Indian Evidence Act. Now, that being said, there is another dimension which has flown from the provisions of the Family Courts Act. Is the family court free to lay down its own independent procedure of dealing with the matter, free from the provisions of the Guardian and Wards Act? Now, let us suppose there is a petition, a substantive petition under the Guardian and Wards Act before the family courts. Can a family court dispense with the requirement of GWA totally? Now, GWA requires a petition to be filed, requires a response, requires issues, requires formal evidence, and requires the procedural aspects. These are also contained in every High Court rules, which every High Court makes under section 122 of the CPC, and so that internal rules are regulated. Now, the question whether the family court can do away with statutory requirements of a substantive law are answered in Amal Lohia versus Kiran Lohia, 2021 decision. It's a matter decided on March 17, 2021. I argued this matter in Supreme Court. Now, this is a very interesting case where there was a marital discord between a couple. The child was about 3 years old. The father had filed a petition seeking custodial and guardianship rights. He did not, the litigation was going slow. The mother did not want to part with the child. The father removed the child from India and went to Dubai and converted to Muslim religion. The mother moved a habeas corpus and the father did not respond. The High Court found him guilty. He was convicted of criminal contempt. When he disobeyed the order, the matter reached the Supreme Court. Number of cases were filed and his whole family was involved because everybody had a role to play. So meanwhile, what happened in the family court was the mother moved an application for being transposed as the petitioner from the father's petition as a respondent. The family court allowed the application for being transposed after the husband failed to appear or the father failed to appear. But the family court also allowed an application under section 151 CPC to declare the mother as the guardian on the same day. This was challenged by the father in the High Court. The Supreme Court transferred the matter to the board, and the Supreme Court, by this decision, a 3-judge bench decision, has laid down very important provisions. Now, the Supreme Court says that wrong procedure was followed by the family court. Counsel withdrawing is not abandonment by the litigant. An application under section 151 CPC is not a substantive provision under the GWA. Pleadings, issues, and evidence have to be led. Family court cannot acquire the powers of a constitutional court. Family court cannot pass further orders after it has become functus officio. There should be a child-centric approach. Now, then the Supreme Court said something very important, that the father could not be declared unfit unless there was an issue declaring him as unfit. Now, the Supreme Court in para 25 says, in the Indian context, neither the provisions of the 1984 Act or the 1890 Act, that is the Family Courts Act and the Guardian and Wards Act, envisage a declaration in favor of the parent to be the sole, exclusive, and absolute guardian and custodian of the child. Such declaration has been intentionally avoided by the obtained by the respondent from the family court to serve an ulterior purpose. Now, the Supreme Court further says the appellant has relied on the decision of so and so. According to the appellant, the father, being a natural guardian under Hindu law, is entitled for a declaration of guardianship unless it is found in a given case that he is unfit in the context of the parenting of the minor child. According to the appellant, if the father is a natural guardian, it is contended that unless the father is declared unfit, the relief of declaring him as a guardian cannot be declined. The fact that the appellant had taken away the child from the family court does not mean he was a kidnapper, as he continues to be the natural guardian. So, as I told you, unless and until there is a declaration by the family court that the father is unfit, the natural guardian position cannot be divested from him. So, what is the conclusions which the court drew? Very important for family courts, and particularly if you want to rely on substantive procedure. Family court is required to follow the mandatory procedure under the Family Courts Act and the Guardian and Wards Act. So this means there has to be a petition, there have to be pleadings, there has to be issues, there have to be evidence. Now, after all this is done, how the court proceeds in cross-examination, how the court takes a document, admissible, non-admissible, that is an issue which the court can play around with in 12 and 14. For example, I normally tender an affidavit in evidence as examination by submitting a pen drive, serving the copy in advance to the other side, so that the recording of the statement examination in chief is simpler and quicker, and then the other party can cross-examine. It saves time. So this is how this can be dealt with. Application under Order 10, Order 1, Rule 10, and or how to be dealt with. Abandonment is not to be inferred, but has to be established. Transposing should lead to change of array of parties. Substantial non-compliance of procedure, infraction of principle of natural justice is not a technical irregularity, cannot be oblique. Then fitness of the father to be decided on merits on a child-centric approach. So ultimately what the court did was it set aside the judgment of the family court transposing and declaring the mother and remanded the matter back for a fresh decision on merits. Now this judgment has led to a lot of clarity on what is the jurisdictional aspect of the family courts. Now there are two concepts which I want to share with you. One is, as I referred, the concept of parental alienation syndrome. Now, parental alienation identified in Vivek Singh and Romani Singh has led to a very clear thinking that there should be joint custody, there should be shared custody. Now, the normal viewpoint taken is that this shared parenting and joint custody is not a statutory provision in any act. Now, I tend to disagree, because I say that when you move an application under Section 12 of the Guardian and Wards Act for an interlocutory order on custody in a substantive petition for custody and guardianship, Section 12 says the court may direct that the person, if so, having the custody of the minor, should produce him, and may make such order, I pause, such order, for the temporary custody and protection of the personal property of the minor and things proper. So I say that the word such order for temporary custody have to be interpreted to mean such order. Now, the such order is the discretion of the court. So the word such order in the wisdom of the court can mean a joint parenting or a shared custody order. So by such order for temporary custody, the family court can say, I am not proceeding with the details of the case. I'm not proceeding with the trial of the case unless you come up with shared custody, joint parenting, Monday to Friday mother, Saturday, Sunday father, or throughout with mother, daily access, daily visitation, or daily contact with the father if physically possible. Otherwise, internet, WhatsApp, Zoom, whatever. So it is for you as counsels to tell the court that under section 12, such order is your discretion. And under the Family Courts Act, you are free to break away from the shackles of a conventional law to decide how you want to proceed with the matter, because under section 12 of the Family Courts Act, there is liberty to a family court to lay down its procedure with a view to arrive at a settlement or come to the truth of the facts as alleged and denied by the other party. And for this, no evidence act is required. So for this purpose, there is no requirement that should be a joint parenting, that there should be shared custody order, statutory right or whatever. Supreme Court in Amal Lohiya's case has said no parent has an unconditional right to custody. And you cannot divest the custody of one parent just because there are some issues between them. There are only 3 exceptions where custody can be taken away: violence, harm, or abuse. So if per se, apparently, none of the 3 are available, you may be a very bad husband or a very bad wife, but you may be a very good parent. So your rights as a father should not be mixed up as your rights as a spouse. So in this circumstance, in this question, in this perspective, seeing parental alienation syndrome on one side, we have 3 judgments. Savita Sitaram, 2020, a division bench of Karnataka High Court. In para 96, they deal with the welfare of children with both parents and shared parenting. I'm not going to read the judgment because it will take a lot of time. Then is JK versus NS, 2019, Delhi High Court. Then Tushar Obale, Supreme Bombay High Court judgment, para 19, it is ideal for joint parenting to be a rule. Single parenting should be an exception. Now, a lot of people say that there is no hard and fast rule that there has to be shared parenting. Now, I think the word such order under section 12 and the freedom of the family court under section 12 of the Family Courts Act, if read together, are free to good advocacy to urge before a court that there should be a shared parenting plan, there should be joint custody, particularly when the Supreme Court and so many judgments say that it is in the interest of the child that the child should be with both parents. Now, I must also share with you what the Supreme Court has said in Yashita Sahu. Yashita Sahu is a judgment of the Supreme Court of 2020. It says the child is a victim in custody battles. It is in the fight of egos and increasing acrimonious battles and litigation between 2 spouses. Our experience is more often than not that the parents who otherwise love the child present a picture as if the other spouse is a villain and he or she alone is entitled to the custody of the child. The court must therefore be very wary of what is said in the cases. Now, the court says a child of tender years requires love, affection, company, protection of both parents. This is not only the requirement of the child, but his basic human right. Just because the parents are at war with each other does not mean that the child should be denied the care, affection of the other parent. A child is not an inanimate object and cannot be treated or tossed around. Every separation, every union may have a traumatic experience. So the Supreme Court says that even in custody is given to one parent, the other parent must have sufficient visitation to ensure that the child keeps in touch with the other parent and does not lose social, psychological contact with the other parent. It is only in extreme circumstances that one parent should be denied contact with the child. Reasons must be assigned if one parent is to be denied visitation or contact. Courts dealing with custody matters must decide issues which clearly define the nature and specific of the visitation rights. Now, in addition to visitation, they say contract rights are also important. So they have dwelt on this theory and they have come out very clearly with a parallel balancing act which the court has to do. So, four principles which I bring home. Delay in interim hearing is one of the basic causes for parental alienation syndrome. So Section 12 application for the joint parenting plan at the inception of the case is a necessity. Child issues related like maintenance and access must be mutually closed, possibly during counseling or mediation. Shared parenting plan should be encouraged and should be decided at the earliest because prolonging the litigation means alienation. Voice of the child should be heard. Now, Bombay has adopted a very unique procedure. They have drawn up a panel of child independent lawyers. The child independent lawyer speaks for the child. So the voice of the child finds expression. Then bringing children in marital disputes is nothing but giving the wrong impression about relationships. Children observe and learn from their parents. So welfare of the children also enjoins that the parents should settle the disputes amicably for the welfare of the child. Now, there is also another development that POXO is being used to deny parental rights by accusations. So the court has to sift through very quickly if any issues arising to POXO find any importance or have any significance at all. So this is a roundup of the law, which is perhaps being updated day to day. And what I have gathered as my arguing counsel position, as amicus position, or as speaking to a number of persons. So I would like to conclude now, and I would be very happy to take questions as you can regulate best you think possible. But please let the speaker introduce himself. Let there not be any disturbance to the forum of the seminar.
Whoever wants to raise question, first let them raise their hands, and next switch on your videos before you put a question.
Vani ma'am is the first one. Vani ma'am, you have to unmute yourself.
Ma'am, unmute your host. Today I don't have the host powers.
Ma'am, you have to unmute yourself.
Yeah.
Actually, I have locked everyone.
That's why I said today I don't have
I
host
did,
powers.
madam.
Yeah, thank you.
Sir, the
Thank you.
the key is not with you.
There are a few things I just wanted to, elaborate on what Malhotra has said. Number one, the rare cases of the surrogacy. There is a case which I have dealt where the mother gave her ovum and the father his part, and the child was the embryo was embedded in a surrogate mother's womb. The child was born. Unfortunately, there was a conflict between the parents with regard to child custody. The same thing was said by the father. He said, no, the mother didn't bear the children, so she doesn't have a right. But in that particular case, that particular question was held in favor of the mother, that she is also to be considered as the mother of the children, because it is to her ovum that the children were born. Then that is one thing. Then with regard to this jurisdiction, sir, the place where the minor child ordinarily resides is something which there is no particular, enactment or any particular decision to say. It is purely a question of facts. But in the context of this custody petitions, custody relief under the matrimonial act, enactments, definitely the place where the OP can be filed for the matrimonial reliefs would definitely assume the jurisdiction under the Act. And under the amended acts, this matrimonial acts, wherever the wife resides, if it is a petition filed by a wife, the wife can file a petition wherever she is residing. So when she is asking for 13 or 131A or whatever, she can ask for section 26 there, and there the ordinary place of residence would not apply. That would apply only under the Guardians and Watch. Then we have in a case where the territorial jurisdiction is lacking, the sir, with permit me to say, Order 7, Rule 10 would apply, where the court can return for presentation to the proper court.
Yes.
It will not be rejected. It cannot come under Order 7, Rule 11. It has to be only under this. Then, with regard to adoptions, adoptions under the JJ Act, adoptions under Hindu Adoptions and Maintenance Act, there are decisions starting from this Justice Ruma Pal's judgment, Anokha versus State of Rajasthan, where the adoption, if done under the Hindu Adoptions and Maintenance Act, there can be the simple procedure of taking in adoption, giving in adoption and taking in adoption by this Datta Homa procedure, or a deed of adoption which is registered properly. And once that is done, see, in the case of case where the child is adopted in India and has to be taken abroad, there was a compulsory step where the Kara had to be involved and permission had to be taken by Kara. But judgment in Anokha versus State of Rajasthan, and subsequently in a case in 2021, which I did in the court of Telangana, in the case of Hindu adoption, there need not be any permission of Kara for taking the child abroad. For issuance of passport also, there is no particular, any additional permission that is required to apply for and take passport of the child who is given in adoption under the Hindu Adoptions and Maintenance Act. So, to put it shortly, if it is a Hindu adoption, definitely there is no other requirement that comes into operation for the purpose of obtaining some permissions for the child, passport for the child, or taking the child abroad and all. And in Hindu Adoptions and Maintenance Act, sir, one more thing, sir, sorry. In the Hindu Adoptions and Maintenance Act, a man can also take a girl, and similarly, a lady can also take a boy, single. I'm talking about a single parent, if the age gap is 21 years. If the age gap is 21 years, an unmarried girl can take a child in adoption, a male child in adoption. Similarly, a male can take a female child in adoption, subject to the age difference. Then, sir, with regard to child abduction laws in India, since we are not signatories to the Hague Convention, probably there is no such concept of abduction by a child. And with regard to sir, Hindu Minority and Guardianship Act, if there is a question which arises with regard to the custody of the minor child, and if the jurisdiction has to be gone into, it can be only in terms of the CPC, because there is no specific provision given. There is no specific provision in the enactment with regard to jurisdiction, territorial jurisdiction. So, essentially, section 15 to 20 of the relevant provision would be section 20, if I'm not mistaken, of the CPC would apply. Then again, but since all the laws are amended, we may say that a woman can apply where she is living, but there is no specific empowerment. I mean, enabling. There is no section enabling a woman to do that in respect of any provision under any relief under the Hindu Minority and Guardianship Act. So, this section 9 jurisdiction, where the minor ordinarily resides. Sir, please correct me if I'm right. There is no test as such. There could be a situation where the mother is residing at a place, the father is residing at another place, the child is studying in a hostel someplace, at some place. Let us say mother in Hyderabad, father maybe in Bangalore, child is studying in Ooty. In such a situation, where would the jurisdiction lie? And according to me, it would lie at the place where where the minors, maybe going by the present situation, maybe the Aadhaar could be the answer, or maybe the place shown as his place of residence in the school records. This is on these aspects, there is no clarity as yet in judgments. These have to be decided. Then, incidentally, Lahari Shakamuri is a case which arose from the Additional Family Court, Hyderabad. Well, this is about it. And jurisdiction in marital laws. As I said, the jurisdiction section in almost all the marital laws is, now provides for a woman to file a case, initiate proceedings at the place where she resides. So this is it. Please go answer with the questionnaire. Interaction. Yes. Unmute Emma, Sridevi. Sir, unmute chain.
Ma'am, on the issue of jurisdiction, Ruchi Maju contains a lot of information, and I think it clarifies on the issue of jurisdiction. But just to bring home a principle, if a child is forcibly brought to place B and the petition is filed, or the child is present on the date of the filing of the petition, may not be a determinant factor, but it is a question of evidence. If prima facie, it's a prima facie question which has to be addressed by the court depending on the pleadings and the documentation before it. If the court finds, no, the child has been living here for a substantially long period of time, is going to school here, is being present here by the consent of the other parent, then of course the court has jurisdiction. The second aspect I want to clarify is that as far as Hindu adoptions are concerned, there is a lot of problem in taking children out of the country if it is a Hindu adoption under the Hindu Adoption and Maintenance Act. You are absolutely right that the passport officer is nobody to ask, where is your adoption deed? Where is the permission of Kara? There are judgments that passport authority has to only act within the ambit of the Passports Act. But the question remains, we are a signatory to the Adoption Convention of 1993. Now, the Adoption Convention requires that there should be a NOC from Kara, or there should be a conformity certificate confirming that the adoption has taken place in accordance with the convention. So an anomaly comes. I have addressed this issue as an amicus twice in the High Court here in Chandigarh. But then Delhi High Court came out with a judgment that Kara has to give permission for a Hindu adoption. What Kara has done in 2021, Kara has amended the adoption regulations and have provided a mandatory NOC procedure for Kara to give an NOC for the child to be taken abroad for Hindu adoptions. It is not adding to Hamma, because under section 56(3) of the JJ Act, the Hindu adoptions are exempt from the application of the JJ Act. So what is the requirement is the adoption convention is the requirement of an NOC. Hamma is not a requirement of an NOC for adoption intercountry. So because it is a requirement of the adoption convention, Kara has come out with a procedure that the district magistrate will verify the antecedents of the adoption and will grant an NOC. But unhappily, the requirement of the court approving the adoption for all other cases has been relegated to a district magistrate, which is very disturbing. Giving the powers of a court to a district magistrate for giving an NOC in inter-country adoptions is not a good idea. Anyway, that is a subject we can take up separately, but let us leave it to the host for taking questions from the participants.
Just one thing about this Hindu adoption, sir. I was talking about not a foreign national adopting an Indian child. It is an Indian parent adopting a child in India.
No, that will not require any.
Taking the child abroad.
No, even for that, suppose there are Hindu parents of American nationality and they want to take the child abroad. Under the 2021 adoption regulations amendment, there has to be a requirement of an NOC. Now that NOC is not by virtue of the JJ Act. It is an NOC required under the adoption convention, because without this NOC or the conformity certificate, the child will not be given a visa to leave the country. So it is simplifying the procedure, so to say. Best. Take care. Thank you very much.
Thank you, sir.
Thank
Thank you
you
very
all.
much.
And wait for the video link. All the best. Bye-bye.
Thank you, sir. Thank you very much. Sir.
Bye. Bye. Bye.
Thank you, sir.
Bye. Thank you, ma'am. Bye.